Great. We have so many people joining us today, and this is going to be an amazing webinar. I'm going to give everybody just a moment to get all logged in, but I would love to start out by welcoming all of you. You know me, I'm Ginger, the Executive Director for Connectionology, and I'm so proud to be here with you today. It's our last webinar of the year, but don't worry because we have a full schedule for January. I'm going to be adding that to our website later today at connectionology.com. And then I'm going to announce our 3 live seminars that we're doing next year. You guys, it starts with Nashville, which is going to be in May. Incredible TBI seminar. I'm going to put that information in the chat for you. And then we're going to be doing Jackson Hole at the end of September. And then a week later, we're going to do Chicago. So that first week in October. So I'm going to put that information in the chat for everybody. But we do want to get started because we have a lot to cover today. If you have questions, I encourage you to ask away. Put those questions in the Q&A box so that way Michaela will be able to ask them to Keith. And we'll also keep an eye on the chat box as well. But it is my great honor to go ahead and introduce one of our moderators today, which is John Romano. And as you guys know, he's the founder of the Romano Law Group in West Palm Beach. But a neat fact about John is he actually, before he came one of America's beloved trial lawyers, he was actually a captain in the Marine Corps, the United States of America. He's board certified. He's gone to trial in just about every type of civil and criminal case that there is. And he was also inducted in the Trial Lawyers Hall of Fame in 2016. He is an author. He's one of the most sought after speakers in the country. And he's also past president of the National Trial Lawyers, the Melvin Belli Society, the Southern Trial Lawyers Association, as well as the Florida Justice Association. But we all know that at home, John is actually the vice president. And I love to say that. He's been married to his beautiful wife, Nancy, for over 51 years, and they have 11 beautiful grandchildren. And John, I couldn't be more proud of you, and I'm so excited for this webinar today.
Ginger, you are amazing, and I want everybody to make sure you go out of your way to thank Ginger because she is our executive director who makes all of this happen. And when we are off doing so many other things, she is thinking about CLE to make things better for us, meaning for our clients, for our staff, for our families. Thank you again, Ginger. You're just amazing and spectacular. I am beyond thrilled, excited about today. I'm going to tell you a little bit about our featured speaker in a minute. You will see up on the screen the young Michaela Taylor. She is one of our new lawyers here at Romano Law Group, and I thought it would be wonderful to have Michaela be a part of this so that as a younger lawyer, a newer lawyer, and someone who in law school in her own right was a mock trial champion, is going to have some really interesting questions for Keith when we get moving along, and Michaela is going to handle the questions that pop up on our Q&A. Keith Mitnick, an honors graduate in both college and law school. Verdicts in every type of case you can imagine for almost 40 years. He is the senior trial lawyer at Morgan & Morgan, which is not only one of my favorite law firms on planet Earth, but some of my favorite people are in that firm. And the Morgan & Morgan firm, as anyone watching this knows, is one of the great premier law firms in America, bringing us leaders, bringing us verdict lawyers, bringing us all types of inspiration. Keith has handled literally dozens of high-profile cases, including one where he represented the Backstreet Boys, another where he represented Curly Neal and Meadowlark Lemon as a part of the who were part of the Globetrotters in a lawsuit. And there have been so many more of these high-profile cases. He's in super lawyers every year, best lawyers every year, recognized everywhere as one of the greatest lawyers in this country. And I can tell you this, folks, having been involved in lots of trials and having been connected to a lot of trial lawyers over the years, I get to see it all. I get to see the one-hit wonders who talk about one case their entire career, and I get to talk about the great ones. And Keith Mitnick, it's like every time I call up to speak to him, he is in trial somewhere, and they say, but he'll call you tonight, and he will call me that night. Keith has been a remarkable leader, not only in our profession, but for everybody connected to the legal profession. And he's done this since day one. A mentor. I don't know of any lawyer in the country who is more of a mentor. You talk to lawyers all over the country. I don't care if they're older or middle-aged lawyers, experienced veterans, brand new lawyers. You'll hear stories like this. I called to Keith Mitnick. He got on the phone and we spoke for an hour. That's what he does. Keith spends his time out of the courtroom trying to help clients, trying to, of course, spend time with his family, but also trying to make all of the rest of us better in everything that we do. A motivator, a motivational speaker, an inspiration. Verdicts, listen to this. 18.1 million, 27 million, 40 million, 90 million. He knows not only how to consistently get these extraordinary verdicts in death and catastrophic injury cases, but I will see him try a case where many lawyers I know are settling a case for $253,000 and $400,000. He says, no, we're going to verdict in that case. He will try that case and come back with a verdict, 3 million, 4 million, 5 million, 10 million, 15 million, because he has such a unique and wonderful way about him and about trying those cases. There are 2 books. Every trial lawyer's got to read them, and I would say memorize them. I'm exaggerating there, but you got to know everything that's in these. Don't Eat the Bruises, one of the leading books on trial advocacy, discovery. You got to get it, you got to read it, but you got to take your yellow marker and spend time when you read it. More recently, his new book called Deeper Cuts, do the same thing. Spend time with these books. You don't just read them and set it down, you study them, just like you're going to school and getting ready for a final exam. So now I've told you about Keith, the lawyer and the author, the speaker, but I want to share a couple of other things. I've seen Keith when nobody's looking at him, when he's dealing with a staff member at a hotel, when he's dealing with the IT person who's setting up or helping him set up before he gives a lecture. He treats them with such dignity and respect and kindness. And when they walk away, they go, that man there is so different from so many of the people that I run into. That tells me so much about the Keith Mitnick we know and love. He is an extraordinary human being with a heart and soul that you just can't measure. And the way he treats people when others are not looking is what tells me so much about the greatness of Keith Mitnick. I am so honored that we have the privilege today to have you with us, Keith. And all I can say is thank you for being here. And we can't wait to hear what you've got to say. The floor is yours. Keith Mitnick, everybody.
Thank you, John. I am really touched. Thank you very much. I will say this, I was watching you and listening to you before we started, and what came to my mind is there aren't a lot of legends, but there are even fewer legends that are as classy as John Romano. And there's not a lawyer in this country that I speak to that A, doesn't know you, and B, doesn't start out with, they always say he's one of the greatest ever, but they always finish with, he's one of the kindest, classiest human beings you'll meet in your life. So I want to return the compliment simply because that comes from my heart. And it comes from the heart of America.
Thank you, Keith. That's beautiful. That's beautiful. Thank you.
It's hard to do what we do in the world of combat and maintain your humanity and your classiness and your kindness. And no one has demonstrated that to all the other lawyers how it ought to be done more than you have, including to me, by the way. So having said that, let's get started. I want to talk about something I labeled. I like to put things in reproducible processes, reproducible systems, rather than just tell a war story. Because the war story may sound impressive, but it doesn't do you much good. If you want to really truly share with people something of value, I know from personally, I get a whole lot more out of it when someone shares with me something that is in a framework that I can drop down in any case, anytime, and actually get some use out of it. So I try to do that. So these are things that I had been doing, that when I wrote the second book, Deeper Cuts, I needed to put it in some structure and framework so it would maximize its utility to others. And I called it Maximum Damage Matrix. And what it has is there are two parts. I'm sorry, there are three parts to it. There are two of them that are specific to damages. There is a part that is not generally to damages, is really for that case involving like a herniated disc case where it's a pain. Someone is living now with pain that's been thrust into their life that they're now having to manage for the rest of their life, but you can't see it. And we know how defense lawyers will exploit and distort the fact you can't see it to make it look like it must be exaggerated, it must not be real, it must not be that bad since we can't see it. So the first part of the maximum damage matrix is what I call putting an end to belittling pain. And while that isn't specific to the damages, it is a lead-in to then in that very, very common trial, it is a lead-in to the second two pieces that apply to any kind of case, even if it's a kind of case you can see the injury. And the next two are what I call the dignity of damages. And what that's about is we all, listen, what we do is hard. It's hard physically, it's hard mentally, it's hard emotionally. And one of the hardest things we do is constantly being ridiculed because we're in the business of getting remedies for people who have been hurt. And the remedy is a monetary remedy. And that is a righteous remedy. But for goodness sake, all of y'all know what a beating we take over that, as if that is some kind of money grab or greed or ambulance chasers, or we profit off of other people's suffering. And so this section on the dignity of damages has a dual purpose. It's to remind ourselves we should be proud of what we do. And in the process, we lift up in the jury's eyes, we put this concept of monetary damages as a means of recognizing what was taken from someone in the way of health up on a pedestal where it belongs, not a false pedestal, not a trick so we get a big verdict. It is an opportunity to be also not only representing your client, but representing what we do as almost a liaison or a spokesperson for the proud part of what we do in seeking monetary damages in a legitimate case for someone who is legitimately hurt. So that part I call is there two parts, and then the second part to that is what I call the dignity damages, and the final part is what I call the audacity to ask. And I took the audacity to ask term from John Morgan. But when he said it, I thought, I love the sound of it. And I know what he means. But I worried that it could have a negative connotation. But I've gotten past that. The negative connotation of audacity to ask could sound like showing off, strutting. Look what I can do. That ain't what John meant at all. He meant having the courage to ask for what the case is really worth, rather than asking for some discount because we are afraid someone might look at us cockeyed or look down at us or laugh at us or scorn us. And his point was, you got to be brave to do what's right for your client. And the more I thought about it, I thought, you are falling prey to that very concept by hesitating, embracing that phrase. And so I said, by God, that's going to be the last step, audacity to ask. And I'm always going to explain what it means. So if there are any naysayers who want to put a negative spin on it, I'm going to put a stop to it right now. because that's not how it comes, but it certainly is a significant part of what we're doing. So let me work through that. And when I get to the audacity to ask, when I get to the dignity of damages, I want to not only talk to you about how to, some suggestions that work for me, and I know others have done them and they reported back they work for them, that I want to share with you on how to best get a full and fair verdict for each of your clients every time you walk in court. And by the way, these concepts also add to the value of your cases from a settlement perspective. But I also want to take a few minutes when I get to those parts that are pure damage parts of this to talk about kind of a pep talk I've had to give myself and to share it with you, because a big part of this is our own personal belief in what we're doing and some of the little bit of time I had to spend alone with myself to make sure I was in the right state of mind so I could sincerely present it to a jury. So we're going to cover all that. But let me start with this piece that is limited to the pain type case where you can't see it, which would include, of course, traumatic brain injury, herniated disc, anybody's got, or RSD. I'm showing my age. I know we call it something different now, but I grew up trying cases when it was called RSD, those kinds of injuries. And I'm going to focus primarily on the car crash, herniated disc case. In the typical case, in typical, I mean, it isn't perfect. You've got gaps in treatment. You may not have a lot of visible property damage. You may have some prior incidences. You may have the disc may have been injured before, and this is an aggravation. You may have some subsequent injuries that have occurred since the one that you're representing your client on, that the defense tries to hide behind or diminish or say that must be where it all went. Or maybe your client didn't go to the emergency room right away. Or maybe your client didn't go to a doctor for a couple of weeks. Maybe your client got a surgical recommendation and didn't do it. Maybe your client got frustrated and stopped going to the doctors altogether for a year. All those type things I want to distill down into what I call your typical or common or usual car crash case. That's really where I designed putting an end to belittling pain. And you know where it came from? I am a very, very blessed, fortunate guy because I get to spend a lot of time in front of juries. I don't have to I did many years work cases up. Believe me, I know the value of a workup. I've done it forever. I actually love that part of the case. But all I do and have done for 20 plus years now at Morgan & Morgan is just take the cases other people have worked up and step in to help try it with the lawyer that worked it up. And what that means is I get to see what the defense is doing over and over and over and over, and not with a year gap, not with a 6-month gap, but maybe a week gap, maybe not at all. It may have been last week I was in front of another jury. And you get a perspective of, I can see so clearly, my eyes wide open, of what they're doing and why it's wrong, but why it works if we don't point it out. So all of this has come from a place of, I want to put a stop to these routine things in a way that everyone can take it and adapt it to your own style and personality, take parts, throw out other parts. But the concepts truly are meant to say enough is enough with this broken down effort to make it all look phony, fraud, exaggerated, not really hurt, and if at all, not very badly. And I'm so sick of hearing it, I finally kind of said to myself, enough's enough, and I developed things to deal with it. And that's really the backdrop of putting an end to belittling pain. So let's get started now that I've kind of given you the 10,000 foot view of it all. I use these kind of phrases and things in talking to the jury. And I'm just going to model if I'm talking to jury in closing argument. And I'm at to the point where I'm ready to go into the putting an end to belittling pain, which I do just before the dignity damages, just in last will come the audacity to ask. And I will tell a jury, and I usually, by the way, start this concept in voir dire in an opening, but here's kind of, I want to do it in closing where I don't have to be careful how I say it, and I can truly bring it all together to its ultimate point of power. And I tell the jury, this isn't the kind of pain that you can see looking at from the outside. It's there, it's real, and we can test it, and you can see it. And you don't just have to take my client's word for it, but you have to look in the right place. It is not cane pain, meaning not the kind of pain someone needs a cane to get around with. It's more what people often will refer to as pilot light pain. The reason it's called pilot light, for those of you that are old enough, like I am, to have been around when we had pilot lights on our hot water heaters or our ovens, there was always this little flame flickering. And when you needed it, you turned it down and it would flare. But when you turned it off, it didn't go away. It just went back down to the constant, always present flickering. This kind of injury is often called pilot light pain because it never goes away. My client lives to one degree or another with some level of discomfort or pain. And depending on what she does, she lives bouncing between constantly pilot light to flare up and in between. But no, light's gone out and I have peace. And it is important to understand that kind of an injury is not an external assessment injury. It's an internally assessed injury. Externally assessed injuries can be horrible, but oftentimes they're not nearly as big a deal as the internally assessed. Why? The external one hurts a lot. It's extraordinarily intense, but it's short-lived. So it's not near, it's a big deal when it happens, but measured against time, it is not that big a deal because it heals and goes away. For example, someone breaks their arm. Well, you don't need an internal assessment. The cast gives it away. Someone comes in with a twisted ankle on crutches. Well, the crutches give it away. And if that wasn't enough, roll up the pant leg and take the ace bandage off and look at that nasty purple swollen up ankle. And you go, oh my God, that's nasty. So you don't need anything more. You can just see it. But guess what? Neither of them a big deal because they are a big deal while they're happening. And the reason they're so obvious and you're hobbling around and need a cast is the intensity of the pain it causes. But it's short-lived. These kind of injury, the kind of injury my client lives with, isn't up to that intensity, but it's always ever present. It's a forever injury. There is no time off from it. So it is a very big taking of someone's health for which the others aren't. And do you have to take someone's word for it? No. Well, you just got to look in the right place. What's the right place? Well, let me give you an example and we'll come back. If someone turns 50 and their doctor says, you know what, their primary care doctor, it's time for you to go get some screening for coronary artery disease and cholesterol. Make sure you don't have anything going on inside. And they send you to the cardiologist. Can you imagine him saying, put on the robe, all right, turn. Oh yeah, I know, I see your hiney. Don't worry, I've seen them plenty of in my life. Okay, you look great, go home, fine. No coronary artery disease, no cholesterol. Go home and have a steak and a beer, you're good. I mean, you'd go, you're fired. That's not how you assess that injury. How do you assess it? But does it mean you can't? Of course not. You put them on a treadmill. It checks the inside. You draw some blood. It checks the inside. Well, this is the same thing, except rather than drawing blood or putting them on a treadmill, what do? Well, we run MRIs, and MRIs look on the inside. MRIs don't lie. And guess what? The beauty of the MRI, if in the world of justice, is you get to see it with your own eyes. You don't have to take even the radiologist's word for it. You're going to see it. You're not even going to see this broken disc, this herniated disc that was not in its natural state, in an injured, broken state. You're also going to see this increased signal, this white area that is going to show you that it's not some long-standing degeneration, aging. It's a recent onset from trauma. It's called acute, meaning it's happened recently. So yes, you can look at it, and yes, we can test it. You just don't do it by watching how they walked in the courtroom because they're walking perfectly normal. When we go to lunch, they look normal walking. When they walk to the witness stand, they're going to walk up normal. They're not going to be carrying a cane because it's not that kind of pain. It's not cane pain. It's pilot light pain. You can see them on Facebook and they're smiling and they're active because it's not the kind of injury would prevent that. But it's a very, very serious injury. So let's talk about why is it so serious? Because it's the kind of injury that doesn't interfere so much with the doing currently now as it does with the experience of doing. I want to say that again because it's important. It's the kind of injury currently today now isn't interfering as much with the doing as with the experience of doing. But the experience of doing matters a lot. Life can be hard. Life's not all pleasure. That's why as human beings, we treasure pleasure. The pleasures in life we treasure because lots of life is anything but pleasure. And when you have this kind of injury that's always there like background noise, it's like walking in a department store where they got that hiss sound you can barely hear, like a dog whistle. And it drives you batty. You want to get out of the store. That's what this is like. It's there always. And it takes a toll over time. It doesn't take a toll like right now and I need crutches. It takes a toll because it takes in little bits, but it takes little bits every day, every week, every month, every year, forever. And that's a lot of taking of the peace of a moment, of the enjoyment of a moment. And guess what, folks? This is as good as it's going to get. As the natural aging process overlays on top of those damaged links in her spine, it's only going to get worse with time because the spine never gets time off. Everything, look down, look up, look left, look right, sit up, sit down, lay in bed and try and get comfortable. The spine is always under stress. So when you break the link in that chain, and it doesn't work right, and now it's constantly underused, the wear and tear that is going to take a toll decades, many decades from now, is taking a toll on the brokenness now and making it more broken to where before long, sometime in her future, not way off, it's going to start interfering more and more with the doing in addition to the experience of doing. And this is a verdict for all time. We don't come back in 10 years, 20, 30, 40 years and redo this and call you back. We get it right now or we don't get it right at all. But let's for the moment stay now. So it doesn't interfere so much with the doing currently. It's the experience of doing that it puts a damper on. Let's talk about that because that's no small matter at all. Because those experiences matter. Someone with this kind of injury can still sit in a movie theater and enjoy the movie. They'll laugh at the funny parts, cry at the sad, go, ooh, when it's scary, and walk out and say, wow, great movie, or wow, that one stunk. It didn't keep you from going to the movie or enjoying it, but it was a different experience than if someone was sitting there just watching the movie, a moment to escape into the movie and forget everything else. There's no escaping the pain, even when you're entertained. The person is sitting there the whole time, fidgeting. And if it didn't come about naturally, but it was thrust into her life unnaturally by no fault of her own. One moment she was minding her own business on the road and someone came along driving dangerously, endangering the motoring public, not doing their job, acting unreasonably, rammed her. And like that, this was thrust into her life unnaturally by no fault of her own. It wasn't there before, it's here now, and it's never going away. So when that person's in the movie theater experiencing, it's not just the fidgeting. It's that in the back of the mind, you want to tamp it down and not think about it. But it's the what if that person had been paying attention and doing their job, I wouldn't have this. It's extraordinarily frustrating, but they still enjoyed the movie, but it's a different experience. They can go to a religious ceremony and get a lot out of it, touch their soul, just what they needed to hear, lift them up, teach them a lesson. They still get all the goodness from that presentation at a religious ceremony, but it's a different experience because they're sitting there thinking, as good as this is, I'll be glad when it's over so I can stand. I need to get up. I need to move. I'm really starting to hurt. You can participate in sporting events, still watch them for sure, participate. It's a different experience. The person says, you know what, before this, I would have gone all out. I need to take it easier. I'm going to be on the heating pad. Or they go ahead and go all out, but they're popping a pain pill or an Advil. And as soon as they're home, they're on a heating pad. Didn't do that before. Before they went all out and then went and had a beer and laughed and had a blast. I'm not saying you couldn't still do that, but it's going to be with increased, more intense. Now we're not in pilot light pain. Now we're in the full flare up, and they're sitting there still having fun, but kind of having to grit through it. That's what we're talking about with this kind of an injury. And it's like this. Let's say a guy goes to bed, wakes up in the morning, crick in his neck. He slept wrong. And he goes, oh, his wife says, what's wrong? I slept wrong, got a crick in my neck. Well, I'm sorry, honey. It's not that big a deal. And he goes to work, and every little thing he does at work, every little thing he does, it's there. He picks up his briefcase to go to his cart. There it is. He gets in the cart, tries to look in a blind spot. It's there. He still does it, but woo. Gets to the office, sits, head down working, goes, woo, I need to move. Gets up, walks, feels, relief. Pretty, after a little bit of time, standing up's bothering. So now he's sitting, he's up and down all day trying to manage this nagging, gnawing, irritating pain from the crick in his neck. Goes home, same thing in the car, walks in, his wife says, how you doing? He goes, all right, just this pain. That's like, you know, it's not fun. So I said, maybe you ought to go to the doctor. Nah, it's not that kind of thing. Goes to bed, wakes up day two. Day two, he goes, oh my gosh. Wife says, what? He goes, I was hoping it'd be gone today. Goes to work all day, same thing, living with it, all the little things that he does, it's there. Making many little choices, get up, get down. It's there. You know what he doesn't do? He doesn't call in sick. It's not that kind of pain. You know what else he doesn't do? He's not walking around going, ow, ow, ow. People that say, you big baby, get a grip. It's not that kind of pain. Nobody at work would have a clue looking at it from the outside. And he isn't coming around telling him because they got their own issues. He doesn't want to hear him whining. Then he goes home. Now it's starting to really get on his nerves. It's now been 2 days. He walks in the house and he's cranky with the kids, and his wife says, what's the matter with you? Because he's not normally like that. And he says, I'm sorry, this crick in my neck is putting me in a bad mood. And she says, well, maybe you better go to the doctor. A little less concerned, a little more not wanting to crank in the house. He goes to bed, wakes up day 3, wife's in brushing her teeth, and she hears, hallelujah. She goes, what? He goes, it's gone. Well, that's what my client's life is like, except there is no hallelujah ever. And I said something, folks, I want you to think about in describing that analogy that is so appropriate for what my client lives with. And that is all the many little choices that he's been thrust into his life unnaturally. His freedom to live life without having to make one after another little mini choice, do or not do, knowing if he does, there's a consequence. And if he doesn't, then he will have given up something he otherwise would have done and sacrificed that. That's what I mean by it is taking his freedom to just do. Now he can't just do it without running it through, do or don't do, knowing the price I'm going to pay. I'm going to be in flare-up time. I'm going to be on heating pads and be laying flat on the floor. I'm going to be taking that medication I don't like taking. I'm going to be back at the chiropractor. It's going to be time for more injections. All those little choices, some of them with big consequences, some of them with small. That's his new life. And it is a freedom he's lost to not have to go through that process over every physical little thing he wants to do. Now, let me stop. I am sure I've left some of it out because I'm doing it from memory here, but that's the gist of it. I would suggest I've laid all of this out in explanation and why I did every piece and the detail of it in deeper cuts. And if you don't have it, and please, if you don't have, don't eat the bruises. Don't say, well, I'll get the new one, the old one's outdated. It's like having a computer and you need the mainframe, and now we've got an update to it and everything runs better and faster, and there's some new things that are really, really important. That's book 2, but you still need the mainframe. But book 2 has this entire section on maximum damage matrix that really lays it out. And I'm sure I skipped some things in there, but there are a couple of them I want to touch. And I always say, here's why I did it, and here's how I came up with it. I share with you in that a process I call the wisdom of the wise. Why are we still right in spite of this fact that's causing me some concern? So on all of these components to putting an end to belittling pain, I go through and explain where it came from, what was the thought process and the creation of it, and what it's addressing. And I think when you have that, then you know what happens? People go, I see how you got there, and you start creating your own stuff. And for goodness sake, when you get good ones, send them to me. Because I say, I don't want to be right, I want to get it right. And this is a sharing profession. If it's anything else, people that hoard it ought not be there. And that's a non-hoarder just came up right there. He's a sharer too. So anyhow, that's the gist. Just very briefly, I want to touch a couple things. Why is the crick in the neck so important? Because we can't golden rule jurors, but we're allowed to talk about personal experiences. When you give an analogy of a crick in the neck, that's a personal experience every juror will have, and they will remember how it sounds like you're being a baby and complaining. They go, no, that wasn't a little thing, that was driving me batty. And then they remember the relief when it was gone. Then they think, what if it hadn't gone away? And then what's the next piece? I get questions all the time, and they're very smart questions. I worry about it too. All those people that got bad backs, they can relate to you. They can empathize, but they're thinking, no one gave me a bunch of money. So what do you do with that? That's the piece of thrust into her life or his life unnaturally, and almost biblical, it's sinful, unnaturally, by no fault of their own. Didn't have it. This person wasn't doing their job on the road, hit them, and now got it. And now it's never going away. So you can get the no downside. You can get the empathy of understanding how it is from folks that are suffering with bad backs on your jury, but explain to them why this is different. What if you didn't have it and some jerk did it to you? Then they go, I see why that would be a big, big deal. So in the last little thing I do remember I left out of it was when we talk about the experience and when we talk about the pleasures of life and how people treasure pleasures and life's not all pleasure, part of that is I weave in jury instructions, and most states that I've been to, and I've been to a lot of them trying cases, have some version of what we have in Florida, which is the impact on the enjoyment of life. I call them human damages, quality of life damages. And you can weave into that the strength of having the law standing behind you and saying, and it's not just me telling you, and it's not just common sense telling you that the experience of things matters, that it's important. The judge has told you, you shall consider as one of the items of injury to be considering is the impact on the enjoyment of life. That's a fancy way of saying it interferes with the experience of doing. So anyhow, that's the gist of putting an end to belittling pain.
Keith, I've got to tell you, I'm sitting on the side of the table over here taking notes.
Good.
I can't write fast enough, but the great thing, I got my computer screen here and I got these emails coming in, one right after another. And a guy from California who I don't know, but he's attending, and his name is Ernest. I hope he doesn't mind me mentioning his name, but Ernest said, Mr. Romano, this is crazy. And then words to the effect, this is not only changing my outlook on my cases, my life is changing before me. I went, wow. I think
Thank
that's
you,
just
Ernest.
incredible. Yeah.
Ernest, you just made this Monday afternoon all worth it.
So Ginger, I'll turn it over to you.
Yeah, this is amazing
And,
information that you're sharing.
one more thing, everybody know, just a few minutes, we're coming back with part 2 of Keith. So hang there with us. Go ahead, Ginger.
Yeah, absolutely. I'm really enjoying this myself. I'm like learning so much from you, Keith.
Thank
And I tell you, I can't wait to hear what you're going to talk about in part 2. Before we get into, I see some questions that are coming in for your part 1. I just wanted to welcome our 2 of our amazing partners. We've got Mike Seeley with HMR, and then we have Kim, who's with OnPoint. And so I want to give them the chance to talk a little bit more about what they do, because they do so much amazing work. They've got incredible teams. And Mike, I'll let you go first. If you don't mind, share a little bit more about what you guys do at HMR, because
Sure.
we're just so proud of the work that you do. And I
Sure.
do know that we're going to have a coffee giveaway at the end of this
Oh yeah.
our webinar. Can't wait to see who's going to be.
Hey, people usually treat you pretty well if you leave something at the end. So that's, you know, kind of their MO.
And everybody loves Ted.
I'm Mike Seeley. I'm the Southern Regional Sales Manager for HMR Servicing Company. We're a medical funding company, and we have a couple of non-recourse funding options for plaintiffs out there. One of those is straight medical funding, which can be used for things like spine surgeries, bones, breaks, complex TBI surgeries. We have networks of providers nationwide that you can use for us to step in and fund those cases, so you can worry about the legal part of winning your case, and we can handle the medical side. The other product that we have is pre-settlement funds for things like living expenses, direct deposits, direct payments to providers, or even making deposits for surgeries. Like if you have a surgery center that's requiring $25,000, $50,000 surgical deposits, that's something that we can disperse directly to a medical provider, so that does not have to come out of operating expenses. That's just a couple of things that we offer. The great thing about HMR, it doesn't always have to be our way. If you have a creative way that you want to do something, bring your suggestions to us. We love to hear those options, and a lot of times, you know, we want to work with you. It doesn't always have to be our way. We like for it to, but we understand that's not the way it works. So we're flexible, and just give us a chance and pick up the phone, send us an email, tell us about your case, and we can come up with a solution for you.
Mike, thank you. Great job. I just want to thank you and HMR for all you do in helping support Connectionology Seminars of America. I want to thank you in advance. I know you all have agreed to be the grand sponsor for our upcoming TBI live seminar in Nashville in May, which we're very excited about. But what people love about HMR is your responsiveness and ability to jump on a case, which helps the client, it helps the lawyer, and therefore everybody in the system who's working that case. And that makes all the difference in the world. And that's why our firm works with you. We've been working with you in the past. We'll continue to work with you in the future. So thank you.
Well, thank you for the kind words, John. We appreciate it. And we're honored to be a part of Connectionology.
Absolutely. And Mike, don't forget to put your information in the chat box for everybody, okay?
I sure will. Thank you, Ginger.
Yep. And Merry Christmas. And I'm excited to say I will see you next year, okay?
That's right.
Bye, Mike.
Bye-bye.
And now I'm really excited. You guys get to meet Kim with OnPoint. Again, I just cannot say enough good things about OnPoint Legal Nurse Consulting. She's going to tell you a little bit more about what they specialize in, but it's just been such a joy to work with them. Kim?
Thanks, Ginger. We feel the same way. We're so excited for this opportunity and thankful to be here. To tell you a little bit about us, we are a legal nurse consulting and expert witness firm. We've been supporting attorneys for over 25 years on any cases involving illness and injury. So we have 5 programs to really assist you with. The first one are record retrieval and indexing. So we all know how difficult it can be to get to the information that you need in the records and to get the records. So we have a team of retrieval specialists who will get the records for you. And then we also have nurses who will do the indexing and bookmarking for you, making it much easier to find the information you need. For a consulting program, Perhaps you're getting bogged down with complex cases. Maybe your paralegals could use some help. And even if you haven't tried using nurses in the past, the nurses in our consulting program, they have a lot of experience helping attorneys, and they help to make the complex information simple. They do this with their timelines and chronologies that include our unique case analysis that outlines strengths and weaknesses, as well as identifies missing records, systems failures, red flags, and possible defense strategies. We can also identify the impact of pre-existing conditions, and we can help differentiate between new versus aggravated injuries. Our nursing home and long-term care program assists with anything long-term care related, from simple thumbs up, thumbs down merit screens to specialized experts who are familiar with those standards of care. Our program coordinator, Ingrid, has spoken on these webinars, and she is a clinical geriatric specialist with over 30 years in that industry. For damages, we excel at economic damages with our life care plans and medical cost projections. And for non-economic damages, I loved what Keith was talking about earlier, because our pain and suffering analysis really helps to explain the client's experiences. Loss of freedom, loss of mobility, we help to identify the experiences that the client's having and pull that information out of the records for you to expand upon. So our goals for you are to make sure you're not blindsided, to simplify the medicine and avoid surprises. We're accessible, easy to work with. You can email me directly, or you can submit case information right through our website on the Contact Us page. Thank you.
Kim, thank you so much for all you're doing. And you all have been so supportive of us at Connectionology, and we so appreciate that. But what I want everybody to know is legal nurse consultants are game changers when it comes to what we do. And just a couple of examples. I know that when we first started working with you all on the pain and suffering reports that you do, it changed everything in the way we were approaching mediations and trial preparation. Another thing that was so vital is when in a number of cases, including the more recent infant formula necrotizing enterocolitis cases, we brought you all on board to help conduct, you all were doing interviews of our clients. It's a totally different approach to interviewing someone, whether it be a client or a key witness. A lawyer, I don't care how good you are, you think a certain way. A nurse has a different approach. It's, you know, Keith, you were a great football player. You'll appreciate this. A quarterback, they walk around, they're visionaries. All they think about is, hey, we're marching towards the end zone, marching towards the end zone. Linebacker, they get their head down and all they're thinking is how I'm going to stop that guy who's singing he's going to get to the end zone. And in all of life, we see that people with a different way of looking at things. You all bring a totally different level to what we do in the handling of these cases. And at OnPoint, you've been so responsive to us. We love working with you, and we're going to keep working with you. And I'm so glad you're on board with Connectionology. Thank you, Kim.
Thank you, John. We feel the same way. Thank you.
Sorry for the football analogy.
That's great.
All I can think now is I'd love to see some old football pictures of both of you. So we need to dig in and find those so I can share them with everybody.
Yeah. Shocked I had full head of dark hair that hung out.
Hey, John used to have jet black hair too. If you guys can believe it.
Yeah.
I think I've seen
He
some of
didn't
those.
lose his.
So, okay, well, I want to thank again, Kim, so much.
Thanks.
Don't forget to add your information in the chat box for everybody. Thank you for being with us. And again,
Thank
happy
you.
holidays. All right, I'm going to go ahead now and hand this over to Michaela because I see some questions that are coming in for part 1. And then when you guys are done with those questions, we're going to go into part 2. Okay?
Yes, so there are a few questions from the audience, Keith. So the first one I would like to start with is if you could elaborate a little bit more on how you determine valuation. So how do you calculate the value of your client's case? And then how do you sell that value to a jury when the defense is saying things like the plaintiff can survive off of 10% of what you're asking?
Yeah, we're going to cover that in what's coming up in the next two sections. And what I'll do is I'd ask whoever asked that, when I go through the methodology of the damage models, my answer is going to be, I start working those damage models behind the scenes to try and get a handle on what I think the case is worth. They're not just a measuring stick for the jury, they're a measuring stick for me to figure out what do I think is fair and reasonable for this, because there's not a formula. So I'm going to answer that as we go. And when we're done, if I haven't answered it, I don't want to leave that hanging because that's such an important question. Please feel free to come back with it if there's another piece of it that I haven't satisfactorily got to.
Perfect. Another question we have is, say your client has a head injury that's impairing their speech and their processing. So they're afraid to go into public and communicate without sounding drunk, for example. So things that are a little harder to prove. How exactly would you go about arguing those facts?
Well, I talk about taking, as you heard, taking someone's freedom to live life without having to make all these choices. And it's not about how much the person is going to get. It's about how much was taken, what's the fair value for what was lost. And those kind of injuries fit perfectly in there. They said, listen, my client used to go out in public whenever, didn't think twice, communicated with people, wasn't embarrassed, wasn't ashamed, didn't feel like a lesser human being, felt like, you know, he or she could hold their own with anybody and fit in with people. And it was part of being accepted. And now my client feels isolated. My client feels like they have lost a freedom to go out in public, not because anyone won't let them go, but going out is humiliating as opposed to fulfilling. And that is a dramatic change. And as a result, my client doesn't go out unless they have to, because no one wants to feel bad about themselves. And they sound funny. They know people are looking at them funny. And so what do? They isolate so they can minimize feeling. And what have they given up? A big chunk of your life is being out in public and socializing and getting work done in public, going to the grocery store in public. Every one of those is a stressor, a point of humiliation, a point of being seen different that they have been seen their whole life by no fault of their own. It was thrust into their life and it's never going away. So that same language, I call creating the language of your case, fits any of these injuries that you don't see, and frankly, any injury. But it fits beautifully into that horrible situation where I hearing that breaks my heart to hear it. And, you know, that's a telling. The person who asked the question has obviously done a very good job of tapping into their client's suffering, because it was communicated third hand through you, and I'm over here cringing. So just take it and then fill it out to the reality of what it means in their life.
Excellent, excellent. And our last question for this session is, how do you handle a situation where the prior MRIs look very similar to the post-crash MRIs?
Great question. And you know, we have so many of these cases. I see every variation. Here's what it's. I'm gonna have to add some caveats because there isn't a one answer fits all to that. If you have an MRI that it's worse, and you have a doctor say that's worse, then I put it in the aggravation, and I will explain briefly how I deal with the aggravation of a pre-existing condition box. If it is truly the same, then it has to be a before and after clinical correlation where the doctors say this has gotten worse. Let me tell you why. You can't see everything on an MRI. The injury doesn't look worse because you can't see the damage to the ligaments. You can't see the damage to the facet joints, and you can't see the toxic chemicals that come out and cause irritation to the nerve roots. And you have to medically explain it, and then have before and after witnesses that are credible that can help bring to life the changes that you're seeing. But let me just briefly touch on aggravation of a pre-existing condition. It's just, you got to remember that with a pre-existing condition, these three phrases, and they fit in so many cases. And the one is baseline, the next word is reserves, and the last word is coping. Baselines, reserves, and coping. And what I will do is I'll take, you can take your hand and say, before this injury, my client was going along in life way up here. And, I used chin, middle of the chest down to your waist, down to here. So I'm kind of working, if I step back from here to here. And I'll say my client was up here. And then unfortunately, my client had an injury before or whatever. And now my client it dropped down, her baseline dropped down to here because she's now got some problems in her spine and it's causing her some ongoing problems. But when she was here, she's still got all of this left from the baseline. She has all that in reserve to help her cope, and she adjusted. She's doing well under the circumstances. She'd love to be back in time before that old injury happened and be back way up here. But that wasn't going to happen. That's not in the cards. She's having to deal with it. But her ability to deal with it, to cope with it, to get on with it as normal a life as possible was much greater because she had so many reserves left. She could absorb it in all this room to cope with it. And then this came along, and suddenly she had already gone from here to here. Now she's dropped to here. And her reserves were so diminished when this happened that her ability to cope with it is much less, and it's having a much more profound impact. That readjusting and recalibrating and getting on with life, she's doing it, but at a much lower level because now her baseline's down here. And it's having a bigger impact on her life because she doesn't have the reserves she had before. She'd probably be better off to have this injury, and she'd have been in perfect health before. The fact of the matter is that she had this pre-existing condition is meaning this injury is worse on her than if she'd have been perfectly healthy before because of the reserves and coping. And when you lay that out, I'm telling you, I've done that with jurors and seen them go from here to, because it's just fundamental truth. It's just putting in words something we understand, we're just not thinking about it. When you properly frame it that way, structure it that way, there's a paradigm shift. And that prior injury isn't a lessening of the value of your case, it's an increasing of the value of your case. And by the way, those same words fit any case. Let's say just your client is overweight and they got a bad leg and they're in a car crash. And they want to say, well, your life was terrible before. How much worse could it be? They don't say it that crassly, but that's the point. And when you start talking about baselines, reserves, and coping, all of a sudden, those prior situations, this is the last person needed something else heaped onto the load they're having to carry. This wasn't an addition problem. This was a multiplication problem. And so that's the scenario where you have a true aggravation. And if you just have no aggravation and they're identical MRIs, then you've got to explain to them honestly, medically, and through before and after witnesses that, the MRIs are just looking from the outside in. They are not perfect. They're wonderful, but they're not perfect. They can't see everything. But we know from a clinical correlation and from these reliable treating doctors, this is real.
Wonderful. And thank you for that perspective. I think that's going to help a lot of us shift our perspective when treating clients in the future. So thank you very much for that. And with that, we're ready to move into your next segment.
All right. We ready to go on?
I believe so, yes.
Real quick, I just want to throw something in so I don't forget from the putting an end to belittling pain. I start that, by the way, in jury selection. And in jury selection, because I worry jurors are already making up their minds your client doesn't look hurt because they look perfectly fine sitting next to you. And I've spent a lot of time angsting over how do I deal with it. And I came up with something simple, and I've done it a bunch of times, and I really find it, I haven't interviewed jurors to see what they think. I haven't focus group it. I've just gotten a bunch of good verdicts with it, and it tells me it's working. And the body language and the facial expressions, when I say this to the jurors in jury selection, tell me it's getting through and hitting the mark. And I say to the jury, we've all heard of the phrase, you can't judge a book by its cover. Here's the frustrating part. We're not allowed to start laying our case out for you, laying our facts out, and then say, how you doing on that? But we also don't get the 3 days into trial and take a time out and say, now I want to ask you about these things. We don't do that. So I've got, even though it's in a vacuum and it's frustrating, I have to ask you the questions now, otherwise they don't get asked. And we all are here, care about justice, and we need to get this right. So I need to ask you some questions. And one of those things is that saying you can't judge a book by its cover. Well, I cannot open the book up and start telling you what's going on inside with my client. I just am not allowed to do that, nor is the other side, by the way. It cuts both ways. I'm not whining. It's just the way the process works. But I can't show you what's inside. But I promise you, the minute that we get to opening statement, I'm going to describe what's on the inside, and then we're going to start putting on witnesses to prove to you everything that's on the inside that's going on that brings us here. But at this juncture, I am concerned because I can't do that. And it is natural for us to judge books by covers. Why? Because it comes from all the way from just fight or flight survival mechanisms. We walk in a room, we're assessing our surroundings. It's natural, it's healthy. We start prejudging things so we don't get caught unaware and get hurt somehow. So in doing this, I know folks come into court and start assessing the circumstances. It's just life, it's people. It's not bad, it's who we are. But I worry you're looking at my client and already making preliminary decisions in your head, maybe not even consciously. Boy, you don't look hurt, certainly not. You've been talking about millions of dollars. This sure doesn't look like that. And here's all I can do is ask you, because I can't fix it by opening the book up now. All I can do in this honor system is ask you to please be aware of that natural tendency and just hold back. Don't start prejudging it. Catch yourself and say, you know, in fairness, let's get to where he opens the book up and I'll start the process of judging then. Is that okay? Can everybody do that and be mindful of that? And I'm telling you, I see jurors go, and they almost have a little bashful look like you got me. Like, yeah, okay. And I believe that stops that in its tracks. Now, I don't do it first. I want to get through a few bias questions, but I don't do it last because I don't want it to get rooted in. I do it, you know, maybe 20 minutes in. I usually put that out for the jury. And it's really not a question with much follow-up other than, can you do that? So I just wanted to add that in because it is a voir dire piece to the putting an end to belittling pain that I think is an important piece of it. So now let's go on to the dignity of damages. So I've told you that the dignity of damage to me is putting this assessing a monetary amount for what was taken in the way of health up in the proper place of respect, not down in a place where we look down our nose at it. And it is this little talk that I do is important because not only am I setting the circumstances and the mood in the enlightenment with the jury, it is also motivational to me. It is putting me, it is a reminder to me of why we are asking for this money. It's putting me in a right state of mind. So when I now do the next phase of the actual audacity to ask for full value, I'm ready. I'm ready. This speech almost brings tears to my eyes because I believe it so deeply. But I want to tell you where it comes from, because part of this, I think I told you at the beginning, is not just communicating with the jury, but it's also communicating with ourselves. Because honestly, your typical like car crash case, herniated disc, is probably worth significantly more than we used to think. We were taught what it was worth when we were young lawyers. Some of you may be young, you just got taught, but you know, guys like John and I got taught about it a long time ago. Well, you know what? Everything else has gone up ridiculously with inflation. You know, you walk in places, there's a place up in Washington, D.C., right by the Capitol that you go, famous place to go eat there. The name's escaping me. Ebbets, the old Ebbets. And they got their old menus and how much it cost. And it was like 2 cents for a steak or something. It's like, wow. Well, guess what? These numbers that we're using today are way outdated and they weren't fair back then. And I'm not preaching to you, goodness gracious, we've just started realizing we've been undervalued cases, but we're not doing it anymore. And part of it is you kind of have to give yourself a little talking to. I did. And I had a case where I was trying with Matt Morgan, John Morgan's middle son, and he went out and Panish is a dear friend of mine, but he's one of John's best friends. And so Matt, when he was a baby, was learning under me and Panish. He had, we kind of both had him under our wings, and he would bring back all these larger numbers. And I'd say, Matt, we aren't in LA like Panish, which is not fair to Panish. Panish, you can put him anywhere in America, he's going to get a great verdict because he's just one of the greatest lawyers of all time. However, that was my reaction. And by the way, Panish didn't try this a car crash case like this. And, I'd say those things, true or not, probably make myself feel a little better. But in any event, I was trying a case and Matt wanted me to ask for $5 million in a car crash case with a herniated disc and all the typicals, priors and surveillance, not gotcha lying surveillance, just actively mowing lawns and unloading big old U-Hauls and things. They just don't look that hurt. And we're going back and forth, and we happen to be at John's beach house, and John says, hey, Keith, it's his case, and Matt wants to just do it. And I thought, okay. Didn't want to sound like a big baby, so I said, okay. But honestly, I've never asked for something from a jury I didn't mean for in my life. So in order to get there, I either had to pass closing the matter, or I had to figure out how to believe in it. And some of this stuff I'm going to share with you was my conversion, my epiphany. I say Matt taught an old dog a new trick, although it's not a trick. I used to say that, I quit saying it. But it's like the mentee taught the mentor a lesson. And I'm glad he did, because it forced me to reevaluate, which I thought I knew because I'd done it for years. I knew wrong. That's just a fact. I know right now. I won't ever know wrong on this one again. So, and part of it was John Morgan did a thing with a bunch of our lawyers. We had an annual meeting, and he said, look, you ought to be golden rule. You ought to think, what if it's you? What would it be worth? Not what someone told you it's worth. What if it was you? And he said, you know what? What if we said someone had a pinky cut off? What would be it worth if it was you? And someone says 100 or 200, and someone said 250, and finally he says, all right, that's the highest bidder. You come on up here. I got a anesthesiologist in the back here. He's going to come out, won't feel a thing. He's going to lop off your pinky. And I'm going to pay you the 250 because I'm going to film it. I'll make 10 times that on the internet, on YouTube. And everybody laughed, but the point was made. You got to golden rule yourself on these. What would it be worth to me? Not what I was told it was worth by a mediator or a defense lawyer or the person who trained me many, many, many years ago. But I'm going to add a piece. Don't look at it, what if it was me, as if it was already over. Because you know what you'll do? You'll fall back into those old unfair lowball numbers that the insurance companies have been quietly laughing all the way to the bank that has been accepted kind of across the board. You will just go to, if you look at it afterwards, your mind is going to click into that range and you're going to stop at the high end, maybe a little more. But if you switch it and say, wait a minute, it hadn't happened yet, and I still have the choice not to let it happen to me, like the person going on stage getting their finger cut off, which of course there was no anesthesiologist back. Morgan was just making a point. But if you look at it, what would it take for me to undergo that loss, that injury, to have that piece of health taken? I can say no. Now you'll get to the root of a real number, a fair number, what it really ought to be. So with that kind of backdrop, I want you to be alert to, as I go through these, some of these were the things I had to say to myself so I could stand up and mean it. Because if I didn't mean it, I'm never going to talk to the jury and say, please do this, when inside I don't believe in it. I love what we do too much. I trust the process too much to denigrate it by doing that. I am not a mercenary. This is a calling. So this is part of what I had to go through to get ready. And I realized, man, that felt good. So when I share it with the jury, I'm connecting with some of the self-talking to I did, and it really has a synergistic effect in preparing me to properly ask for the money. So it goes like this. In America, we no longer do eye for an eye justice. It's barbaric. That's the old way. But likewise, we don't believe in turning a blind eye to justice here in America either, because that's no justice for all. And part of what we founded on is this ideal of justice. So what do? We gather people from the community, like you, to come sit in judgment, to act as a group of assessors of loss, of suffering, of pain, to sit and assess and value what was taken in the way of health. Keeping in mind, it's not about how much she's going to get. It's about how much was taken. What's a fair value for what was lost in the way of health? And in the process, I want to make a point to you that I think is really important. While we no longer literally do eye for an eye justice, the underlying concept is alive and well. It's alive and well, even in the new way we do it. Because eye for an eye justice wasn't so much about punishment as it was about full and complete recognition of what you caused someone to lose, what you took from them. And what better way to have no question about, you are going to fully and completely understand and appreciate and recognize the full extent of what you took when you put that person's eye out is for your eye to be put out. And now you will understand. That underlying concept is exactly what we're doing with American justice. We're just not saying we're going to tear your back up. We're going to cause a death to your spouse. That's eye for an eye. But we are to fully and completely recognize the value of what was taken. And in that way, it is still eye for an eye. Not to punish, but to never shortchange or never diminish the reality, the whole and full reality of what mess you left, what the consequences have been. And with that in mind, I want to point something else out, folks, that is so important. We all know this. And by the way, I cover this in voir dire, but at this point, I'm in closing. We all know this, that the worth of health has nothing whatsoever to do with someone's net worth. Someone who lives in the penthouse does not treasure their health one iota more than the person who cleans the penthouse. When it comes to measuring people's health, everybody treasures health regardless of their financial state or status. Not one penny difference. And what was taken from my client is treasured by her like someone else. And we're not measuring someone else's paycheck or even her paycheck. This isn't about a paycheck. This is about taking the most valuable thing, treasured thing, one of the most important things in people's lives. It's faith, it's family, and it's health. It's one of the big three. And a chunk of it was taken. A healthy limb was replaced with a painful limb that has to be managed. The pain must be managed to try and maintain quality of life. So it is so important that we recognize it's not about how much she's going to get. It's about how much was taken, what's a fair value for what was lost. And trust the process. There were steps before you got here. There'll be steps after you leave. Your job is to sit as this group of appraisers and assess the full value of what was lost and taken, without outside concerns or biases or prejudice or sympathies for the defense, all those things we talked about in voir dire. Now you know why we talked about them. You trust the process and just set the full amount, period. That's your job. That's your duty. Those are the promises that you made in jury selection. Many were called, few were chosen. Not everybody could do this job. I'm so glad. I know it was a long, hard process in jury selection, but now you know why it was so important, because we now have the right people to do right justice, and wrong justice is wrong no matter how you cut it. So I will ask you to do that and recognize, please, this is a verdict for all time. We do not come back in 10, 20, 30 years. We get it right now, we don't get it right at all. Now, I want to talk to you about the damages in this case and share with you fair and reasonable measuring sticks to help you. What I say isn't binding on you. What they say isn't. It's your decision. But I wouldn't be doing my job for my client, nor would I be much of a help to you if I didn't suggest some fair and reasonable measuring sticks and recommend them for your consideration as you go through this all-important process of establishing what is the full and fair amount for what was taken from Miss Jones in the way of health. And that's dignity of damages with a little lead into the next, which is the audacity to ask.
Fantastic. And Keith, before we go on to that third part, which I'm telling you, whew, this is a lot. This is amazing information. I hope everybody's enjoying this. He's watching back home. But before we go into that, I wanted to bring in our last and final partner.
Sure.
His name is Leon, and he works with Plaintiff Support. And I'm so excited for you guys to meet him. I tell you what, if he can't help you today, he is guaranteed to know somebody who can, because he's been in the industry over 15 years. He knows just about everybody out there, and we have loved working with him. I know, gosh, Leon, I think I've known you for 9 years now. Way back when I was working for AAJ, working for the Florida Justice Association. I think we met in Florida. But thank you so much for being here with us today. Are you calling in from New Jersey?
I am back in New Jersey, as John always likes to point out. And Ginger, I don't have enough time, I guess, in my career to know everyone, but I know all the important people and most of the people on this webinar. So
Well, we're glad to have you, Leon, and we can't wait to hear a little bit more about what you're doing and all the good stuff that Plaintiff Support is helping everybody out with too.
sure. Let me just pull up my share screen here. So I'm with Plaintiff Support. We're the first and the original funding company that created this industry nearly 30 years ago. We provide non-recourse funding. We've funded over $2 billion with over 20,000 customers, and we're committed to responsible funding. And we provide pre-settlement, post-settlement, medical, and expert funding. But I know that doesn't really mean much. So let me run through an example. So we were approached by an attorney that had a client that was severely injured in a product liability case that resulted in spinal injuries and paralysis. The attorney advised us that the client was being discharged within a couple of days. They didn't have any insurance and they didn't have any financial reserves, and they called us to see what we could do to help them and their client. Immediately, we evaluated the case and we said, these are the ways that we can help you. We can provide non-recourse plaintiff funding for when the child gets home. You can retrofit the house to accommodate for their paralysis. You can get a van so they can be transported to and from doctor's appointments. You can pay for your prescriptions that they're going to have from now on. We could also provide medical funding, which is non-recourse. Just because they were discharged from the hospital, they had numerous surgeries and rehabilitation that was going to continue for them to even, get close to, improving their situation. The attorney also needed some assistance. It's a big case, and they're going against deep-pocketed defense. So we told them that we could help them with expert funding. So that they could get the product engineers to prove the liability, the medical experts to work up the damages, and the life care planner to show what the future needs of the client are going to be. It was a great result, but as many attorneys know, sometimes the money doesn't come in as soon as the settlement does. It could take a long time, months even, for you to resolve the liens. So we told the family and the attorney that we could actually give them advance on their anticipated fees now, so that they could have some relief, and they can pay us back when they get paid themselves. Since this is the last Connectionology webinar, I want to say it was such a privilege to support Connectionology this past year, and I look forward to I want to wish everyone a happy holidays and a prosperous new year, and we look forward to continuing to support all the great work that you guys do. in the upcoming year. So thank you so much.
Leon, as usual, that was terrific. But I will tell you that although I have known you a long time and you really do know and understand this industry and what it means to those of us handling the cases, you know it as well as anybody else. I did my first case through Plaintiff Support Services going back to around 1999 or 2000 through Joe DiNardo. And then as the years has gone on, we've continued to work with Plaintiff Support and work with you, now work with Dean Chase, continue to work with Joe DiNardo, and we work with Helen, who has always been a phenom there when it comes to plaintiff support. But you all are always there. You always know how to vet cases and how to help the lawyers look into it to see what really is going to be the best next step for the client. And that's what I think really sets you apart. So when you say you're the gold standard when it comes to this type of non-recourse funding, that is so important. It is true. What you all do is really remarkable. And I thank you personally for all of you're such an optimist and so enthusiastic in your support for all that we are doing and teaching, and for people like Keith Mitnick, who are really giving extraordinary amounts of his time to teach and teach and teach. It's important. So thank you to Plaintiff Support. Thank you, Leon.
Thanks, John.
And don't forget to put your information in the chat box for everybody as well, okay?
You got it, Ginger. Thanks.
Thank you so much for all that you do. And you guys check the chat box, make sure you write down this information. And again, I'm going to go ahead and turn it now over to Michaela to see if there's any other questions. And we're going to move into part 3.
Yes, a couple other questions for you, Keith. So one, somebody mentioned that millennials might not know what a pilot light is. And if you could potentially give a more modern version of that analogy.
You know what?
That's great.
That's not the first time I've had that question. And I almost thought, you know what? I'm going to have to come up with something different. And I didn't. And here's why. Let me tell you why. I took it seriously. I now tell jury, I just finished a trial, and I now tell juries, for those of you that are old enough to know, and all the millennials go, they're smart, and they go, all right, I didn't know it, but I understand what he's saying. And so I think it works, but you got to do a little explaining. But I don't want to say all of you young ones that don't know what you're talking about. I say to all of us that are old enough, we remember those little flickering lights that you turn it on, when you heat it up, you turn it down, it wouldn't go off, it would go down and flicker. If you didn't live through those years, I didn't live through Pearl Harbor, but I know the horror of it. So I think you can describe it and people go, okay, I get it. And I don't need them to be masters of the flame. I need them to get my concept. So those kind of questions, thank you, because someone who asked the identical question not long ago woke me up because I hadn't thought about it. And it was a very good point, but I think you can adjust it that way.
I love that. I love that. And speaking as such a seasoned trial attorney, I wanted to know, are there any specific personality traits you think are better geared toward being a successful trial attorney, or do you believe that that's something anyone could work toward?
I think anyone can, and I say it all the time. There are lawyers. I'm more, I'm moving my hands, and I'm a little more animated, and then I know lawyers that are very low key. They never get worked up, and they're extraordinarily effective. They're the voice of reason. They're unflappable. It's like Abe Lincoln in the damn courtroom, and so there's passion, there is unflappable, and there's everything in between. I think the essential ingredient is you got to really care. If you come into it saying, I can make a bunch of money and be a big shot, you're probably going to stink. You got to go into it and say, I'm not in it for the money. I hope, look, you take my money, I'll cut your hand off. But I've never, ever said, hey, if I get this, what's my percentage? How much am I going to get? When it comes, you go, hallelujah, thank God. But the driving force needs to be one of two things, or a combination in my mind. Either you are eaten up with a burning desire to help your client, and or you're eaten up with a burning desire to fight against injustice. They're not going to do this to my client on my watch. I'm not going to let them bully and do this to my client and pull off an injustice. Either one, the fight against injustice or the fight for justice, and the best of all is if they're both combined. But it comes from a spiritual place of believing what we're doing is important work. I just want to say one thing, and I say this to groups sometimes and to myself in private sometimes when I'm down, because look, we all know that do this job, it takes a huge toll. It ain't easy. And when you lose, it's like a family member died. And why do we subject ourselves to that risk over and over? This is hard stuff. And we give much of ourselves. And something that always lifts my spirits is this little saying. How many jobs do you know of out there where someone picks you to stand up for them in a setting where they couldn't stand up for themselves? That's the ultimate honor. And so long as you never lose sight of that lighthouse, that guiding light, all kind of personalities work. I hear people with the squeaky, terrible voices. And next thing I'm on the defense side, and I think, hey, he ain't got a chance for that voice. And next thing I realize they love them. I hear people with Panish's voice, boom, boom, boom. It's powerful, but I've heard them do it and be terrible. What's the difference? It's what's in here. So don't worry about your personality. And one last thing for younger lawyers, please don't feel like it's all about being pretty. And I don't mean physically pretty, I mean polished, perfect. None of us are perfect. We get polished over time. You don't have to be polished to be effective and do something special for your client. All you have to do is believe, and that's in your heart. That doesn't come with time. You either believe or you don't. And you need to walk in with that authenticity, that sincerity, and you have to deliver a winning package. And the winning package doesn't get decided in the heat of the courtroom where you're stressed as a young lawyer. The package gets outside of that. You can talk to your mentors. You can talk to more seasoned lawyers. You can talk to others who you respect that are your same age. You can talk to people that aren't in the law. Talk to your husband, your wife, your friends. And you keep polishing and fixing it and making it better until you finally say, I thought that was good, but that won't work. There's a problem. And now at the end, I've got something that I can turn every which way because I have, and I know it's unassailable, and I know it's truthful, and I know it gives us our best chance. You can deliver that 6 months out of law school as well as John or I could, with the same authority that comes with sincerity. Now, are we going to probably do some of the pieces a little more polished and pretty? Yeah, I know John's got to feel the same way. I want to leave a courtroom and leave him talking about me for years. I want to be memorable. I mean, we all want to be that. The point is that's an ego thing. You ought to drive for it. It's a profession we want to get really, really good at. But that hasn't got anything to do with the winning or losing. That's just patting yourself on the back. The winning and losing comes from you believe in it and they can tell, and the package you delivered was a package that was on the right side. You can do that right now. Give yourself a break. Don't be so hard on yourself that I can't do it like they can. No, you can't, but you can do it the winning way, that you can go away and go, I did something special for my client right now, and the rest will come with time.
I love that. I love that. And thank you so much for that advice, especially as a new lawyer. That's very, very helpful. So thank you for that. And with that, we're ready to move into the last segment.
All right. This is Audacity to Ask for Full Value. And I've already talked to you about how, the golden rule in yourself and all of that. Really, that is the essential part. Because I talked about it on the front end and we're getting late, I'm not going to go back to that. The point is, before you get up and deliver, you've taken down, if you have one of those cases where you need to take down the kind of injury because you can't see it, you've taken down the belittling. You put the damage part you're about to talk to in its rightful place of honor by doing the dignity of damages. You're now ready to roll into the actual where you're going to lay out for the jury the damages. There are really only two parts to it. It is, you have to believe in it. And if you can't get yourself to believe in the number you're going to ask for, have someone else do it or ask for something else, period. So you got to believe in it. And the believing in it is essential, is to do that golden rule yourself before the injury happened, as if you had a choice in the matter. And then start, remember the question we had earlier I was going to come back to. This is the section where I'm going to come back to it. In coming up with the numbers to start with, I almost never do that alone. I'll go a step further. I don't do it alone. I work it alone, and then I start bringing others in to vet it with, to get input with, because I don't have the answers. I don't have all the answers. This part is a mystery. It's not a mystery. A mystery has no answers. This is a puzzle. But there are a lot of pieces to the puzzle, and I want as many eyes on the puzzle as I can possibly get. I talked to my wife about, I would say, I don't know I've ever done a closing argument where I didn't talk to my wife about the damage. She was a court reporter for 20 plus years. She's been in front of tons of jurors, but she sees things different than I do. And together we see things better than either one of us would see. It's like having two eyes instead of one. And I always talk to my trial partner. I often loop in other respected lawyers that I know. I've had Panish call me before closing argument, Mitnick, I want your thoughts on this. Does Brian Panish need Keith Mitnick's help? Hell no. Brian Panish is great enough to know he didn't have all the answers, and I'm going to get the best answer if I get some other people around who I think have good insight. Let's talk it out. So you talk it out and you come up with your numbers, but at the end of the day, the part I apply to get that process started is I start applying damage models. So the two pieces to the audacity to ask is go through the process, whatever it takes necessary, so you believe. So you believe before you stand up. And I will promise you, part of what will get you believe before you ever walked in the courtroom, but what will give you a last minute turbo charge in the believe department when you most need it is that really speaking to the jury from your heart about the dignity of damages. And you will be proud to ask for the number when you remind yourself why we do it this way. And then the second part beyond believing is what I call validating. It's believing and validating. What's validating? I believe in, look, I know great lawyers that pull numbers out of the air and do great with it. I don't claim to have all the answers. I claim to have what works for me, and I want to share with you why I think that way and do it. Take it or leave it. If someone else tells you you don't need all these damage models and they're a lawyer you respect, try it their way. What feels right to you? So from my shoes, from my perspective, personally, subjectively, I feel like I don't want to pull numbers out of the air. I want to validate them with the jury, because I think jurors, to one degree or another, no matter how effective you are in jury selection, there's going to be a little bit of cynical or a little bit of suspicion when you start doing the numbers with them. So I think it is helpful to provide them you validate the number with a damage model that makes sense. And by the way, these same damage models are how I start coming up with the numbers I then start getting second, third, fourth, and fifth opinions on before we actually go to this. And so let me talk to you about some of the damage models I use. And look, some cases I come up with something that doesn't fit any of these, brand new, or some kind of piece together, some hybrid with little bits of different ones. But here are my main ones. The main ones I go to, the very first one I usually go to is a per diem argument. Now, if you're in a state or a venue that doesn't allow some of these, please know your case law. One time I was talking to Panish about a closing. I gave him a great closing argument damage model. I was so proud of it. He goes, well, that's great, Mitnick, but it's a mistrial. So forget that. And we're not allowed to do that now here in California. Okay, well, hell, I didn't know. I went to another one. He said, I like that one better. But the point is, make sure you can do these. There are places that I know states you can't give a number, for God's sake. That's to me crazy, but you can't. There are numbers where there are places where per diem is prohibited. There are places where the classic one of taking a want ad out are prohibited by case law. Don't get a mistrial in closing argument because I said something and you went and used it and you didn't check the law. Make sure you can do it, please. I don't want that on my conscience. But assuming you can, my starting one I always look to is per diem, and I'm going to run through that. Another one that I like to use is multiple of economics, and I'll give you a brief synopsis of that. And then I have one I call what if it was only, if you have multiple body parts hurt. And then I have one that I call the experiment model, which is my take on the want ad. And I'll give you the examples of those four ones I use more than anything else. Let's start with per diem. I used to go do the math on a per diem argument for the jury. I don't, it doesn't feel right. It feels a little too lawyerly. What I do is I describe it and I explain it and I give the jury the number, and then I have on a PowerPoint slide, when I give the number, they put up a slide that shows the math. So if anyone wants to double check my math, it's good. Plus, by creating the slide, I always say triple and quadruple check the math. I got up once where someone else did the math for me. I was literally standing up to give closing argument and they tugged on my shoulder. The judge already called me up for closing and said, hey, my math is wrong in the number. And we didn't even have time to find out how and why. And I thought I was not happy and I had to do something else, but I was glad they told me before the math. Can you imagine get up and your numbers way over what the math was, or worse, it was way less, and the defense says, yeah, I agree with him on that. So for goodness sake, check your math on the per diem. In the per diem, I say that with an assumption everyone knows what it means. Let me not make that assumption. All you do is take your hourly rate, whatever it is, over the number of hours in a day that you're utilizing. You multiply that. Let's say that it interferes with sleep, so you have 24 hours. It would be $10 an hour times 24 hours. Let's say it didn't bother them in their sleep. Well, you'd have 16 hours a day times 10 an hour times, and I saved the 10 for the tail end actually, 24 hours a day times, this would be on my slide, times 24 hours times 365. That's your, obviously the number of days in the year. It goes from the number of hours in a day to the number of days, the number, you go 24 hours a day times 365 days times your life expectancy number, 30 years, times 10 an hour, 15 an hour, 10, 15, 20. I do all kind of variations of it. Sometimes I will take elements of the jury instruction and break them down. Rick Block, who's a fabulous lawyer in our firm, breaks them in each category and he applies hourly rates to each one, and he voir dires that in advance. And as he's got the witness up, he's got a board breaking it down into each one of those categories, and he gets the number of hours a day that they have it. And it works so well for him because it is, very scientific appearing, and it really is a very reliable way to do it. I usually don't do each one of those. Rick does, and Rick's great. I'd let Rick represent me or my family. So I'm not saying his way's wrong. I will sometimes break it into two big categories. If you look and you got 5 categories, 3 of them will fit under the impact on quality of life, and 2 of them will be pain. So it'll be the physical and the mental. Just break it into 2 big categories and explain to the jury I'm putting all these under these 2 bigger categories. And then I put the hourly rate times the hours for each category. But for simplicity, explaining this, let's just stick with the basic $10 an hour. Here's how I do it with the jury. We've got the math slide done. We've run it. We double, triple, and quadruple checked it's right. And I run through this, and now you plant yourself in front of the jury. There can be no rubbing your head. There can be no twitching eye. There can be no looking down. You got to look them in the face, look them in the eyes, and you got to mean it. And I don't mean fake and mean it, because I don't think that's possible. I guess Robert De Niro can do it. I can't. I hope none of y'all can. mean it, really mean it, because you've already gone through the believe process. And so you're in front of the jury and you're boldly looking them in the eye. And I usually, you brought your voice down some because this is an intimate conversation. This is not fighting hand-to-hand combat with the other side on liability. And then I go through the per diem argument and I say, you've heard the evidence, and you go through the evidence in your client, you talk a little bit how it's impacting their life and all the things the evidence showed in the before and after witnesses. You don't need to hit every one. You hit a few of the highlights to bring it back to them. And folks, here is the per diem basic premise that I give them with all the other case specifics that get tied into it. But here's the basic format. We live life as human beings, moment by moment, hour by hour. Sometimes life can be hard. And I can remember times I'd love to skip a day, skip a week. Heck, I can think back not long ago, I could have skipped a whole year if I could have. But we don't get to skip time. We live time. We live time moment by moment. There is no skipping of time. And my client lives with this around the clock, because even in sleep, she doesn't have peace from it, because she has a hard time getting comfortable and staying comfortable. So it's with her to some degree or another 24 hours a day. And if you were to take over her life expectancy of 30 years, merely $10 an hour for having to live with this, that comes to $3.5 million. Now, and I pause and let it sit and look at every juror, because you owe it to them. You're asking them to do it. You need to, you owe it to them to look them in the eye and let them know you meant it. And if you didn't mean it, don't do it. And so that comes to $3.5 million. Now, that's a lot of money. That is a lot of money. But that's a lot of hurt for a lot of time. And it wasn't for everybody. There were many people during jury selection that says they don't want to be associated with a verdict of that magnitude, no matter what the evidence was. That's why we went through that process. But every one of you said you could keep outside concerns out of this process, keep it pure, do your part. This step is your step. There were steps before, there's steps after. Every one of you said, I can put out biases, prejudices, sympathies, outside concerns, and simply sit here as a group of appraisers and assess the full value. And if it is millions of dollars, then you said you would not hesitate because of any of these external concerns. Now you know why I asked all of those questions of you. Now you know why these injuries really are that substantial. The impact over a lifetime is enormous. And I ask you, like we talked about in jury selection, if anyone were to say, well, that's more money than she'd make in a lifetime, or more money than so-and-so would make over X amount of time, please respectfully catch them, but stop it. That is not a lawful measuring stick. In this case, we are not measuring someone's paycheck. We're measuring health that was taken by no fault of her own when this was thrust into her life unnaturally on that day and will never go away. If my client had just been hurt a little bit, like a sprained strain like they've been suggesting, I wouldn't be talking about nearly that much. But those aren't the facts of this case. And you took an oath to assess the facts of this case. And that is a fair and reasonable amount under these circumstances, in this case, not some other case, on these facts, these circumstances, in this case. Now, thank you very much, folks. I'm going to sit down and save a little bit of time for rebuttal and then sit down. Now, I'm going to give you a couple other damage models, but I want to pause there to say a couple things. One, that last little piece is what I call a course correction. I don't care how much you prepared the jury and how well you've done. When you say a number of that magnitude, there is a risk that while you've coming off of the dignity of damages, that you can take a dip. This is a course correction when you say that's a lot of money, but that's a lot of hurt for a lot of time. And then you remind them of some of the jury selection discussions. All of that is a course correction. And then you've done here, maybe a little dip, and you're right back on course for a full justice verdict. Now, one more piece before I talk about a couple of these other damage models. There is a voir dire piece to this. I asked jurors after I've talked about feelings against personal injury suits or med mal or whatever it is. And I've asked about feelings against non-economic, the human damages. Then I will add in, because of the injuries in this case and the facts in this case, we will be talking about millions of dollars, or depending on the case, millions and millions of dollars. Now, they don't agree, but we're going to be talking about that amount when we get into the evidence and really start laying this out for you. Here's what I need to know. How many of you do not want to be associated with a verdict of that size or that magnitude, no matter what the evidence shows? You don't want to report to friends, coworkers, loved ones, neighbors that you signed off on a verdict of that size, even if the evidence supported it. It's just against your beliefs. So what I really need to know is how many of you say, and your beliefs, by the way, folks, you have a right to them. You don't surrender your beliefs because you got a jury summons. That jury summons required you to show up and tell the truth. It didn't require you to sacrifice your beliefs. And if you have beliefs against that kind of a verdict, then we just need to know. We just need to know that you may actually reduce it below what the evidence supports because your beliefs and your beliefs are important to you. You just have a bias, not a hateful bias, a human nature bias based on belief against that kind of a verdict. So I need to know how many of you say, honestly, I have a bias against a verdict of that size or that magnitude, and I cannot assure the court that I can put it aside. I cannot assure the court my decision will be based solely on the evidence presented on the matter, because it may be the evidence plus that belief coming into play before I reach the conclusion. In that space between the facts and evidence and conclusion, my beliefs may have an impact, my bias against those kind of verdicts, and I cannot assure the court that I can put them aside. How many of you would say me? And I go find those people, I establish cause, and then to everybody else, I go to them and say, so are you telling me you would not hesitate to bring back a verdict of that size if the evidence actually supported it? And then you're able to hearken back to that here during this course correction part in the close. Now, let me real quick just hit a couple of these others briefly, because we're rolling up on 5 o'clock and I want to leave a little time for questions. Another one is multiple of economics. And I believe in something I call cross-validating. If I can come up with legitimately, I say come up with sounds like smoke and mirrors. I take back the word come up with, because that's not what I'm doing. If I run these models when I'm doing my starting point, assessing what I think is fair and reasonable in this case, before I start the sharing and getting other points of view, I run damage models. If I run the damage models and they end up coming to a similar number, a very close number, there is great power in cross-validation, because then I can say to the jury, the reason I provided you this second damage model is because they come to very close to the same number. And that is reassuring that those are right numbers, valid numbers, reliable numbers, because we've come from two different, very different approaches, and they've led to basically the same conclusion. And I want to give that to you for your assessment while you do this process that ultimately is your duty and responsibility. And so multiple of economics, I will say to the jury, what it costs to pay healthcare providers to try and help with this situation, knowing there is no cure. They are not fixing it. They're not curing it. All they can do is give temporary relief, make things a little better. And let's face it, the doctors are in and out briefly. And then they go see another patient, another patient, another patient. You may not come back for months or a year. And all between, they're seeing other people doing their thing and moved on with their lives. They come into my client's life. They come into Miss Jones' life for just a few moments. Two, and I don't mean to diminish them. That's healthcare. I'm just making this point of helping you assess the non-economic, the human damages of it. But those economic damages, those medical expenses simply reflect a doctor coming in and out briefly of your client's life to make things a little better, but not cure it. So of course, having to live with this around the clock forever, what it costs to pay those doctors for their involvement pales in comparison to what it is to live with them. That's why oftentimes I'll use a multiplier of 10 to 20 times, or 5 to 10 times, or 3 to 5 times, whatever, feels right to you, genuinely feels right to you. So if the economics are $500,000, I would say to the jury, so if you were to take merely 3 to 5 times, or if you took 5 to 10 times, that would come to, if you took 5 times 500, it would come to 2.5 million to $5 million. That's a fair and reasonable range when you consider the measuring stick provided by the economic damages and the undisputable fact that living with it is far worse than someone just temporarily stepping in trying to help deal with it. And if you look at that number, that's within $100,000 of the number we came up with using the per diem model. And I suggest to you that that is reassuring that we are talking about a fair and reasonable amount for this case. Then, what if it was only? I actually developed this in a case that John Romano will know, Xander Clem, who's a dear partner of mine and friend and a dear friend of John's, the former president of our Florida Justice Association. And Xander and I were trying a case in a very conservative venue, and we had a bunch of very good people on our jury, but they were very, very conservative. We knew from backgrounds. And I'd heard no one in this county's ever had a verdict more than so-and-so. And so I had my models and I was working them, and it was getting late in the night. And I thought, none of these feel sufficient to do the justice in my heart I know needs to be done. And I ended up developing this what if it was only. And what I did is I walked into court, I took a flip chart, and when I got to the damages, I said, listen, it is the easy way for us, me and you, the jury, is to lump all this together with these in a wheelchair. And that's it. Because you know what? It's easier than having to stare into the reality of his life. Heck, he doesn't like staring into it. He is one of the most upbeat people he ever met. But in the quiet of night, you can only keep that front on so much. We've got to go beyond the front. I promise you I won't dwell on it. We won't stay there long. But we both have to be brave enough to look at the reality. And what if this was only? What if the only injury he suffered was the loss of urinary incontinence, bladder incontinence? And I did a mini closing on it, and I wrote a number. And I said, all right, let's leave that. What if his only injury was the bowel incontinence? That's all, the only injury he had. And I did a closing on that. And I put a number on the flip chart. I said, what if it was only his sexual dysfunction? And I did a closing argument. And I think I did 2 or 3 more. And then I ended with the wheelchair. And that one I spent a little more time on. And it was the biggest number. And if you're doing a what if it's only, always use the worst injury for last. So you're kind of building up to it. And then you close it out by saying, the fact that he has each of these he's having to live with. And I could have done 20 more categories and not do it justice, but you know, I think I've made the point. But the point really is the fact that he's living with all of these and then some doesn't make it less. It makes the burden greater. This isn't an addition problem, it's a multiplication problem. So I suggest to you that number is not just fair and reasonable, it's too low. It's the beginning of the conversation, not the end. And I ask you to start there and start thinking about what is the magnitude of all this together and all the things we didn't include in here, because we only have so much time for him to carry the weight of it all. And we went away with what I was told was the largest verdict in that county. And every single one of those jurors, when they walked out of the courtroom, our client sitting there in his wheelchair, either laid a hand on his shoulder or went by and nodded and smiled to him. Those people who are very conservative and never intended to give a substantial verdict like that, not only did, but they knew it was the right thing to do. They were going to carry that as a proud moment for the rest of their lives, not because some hocus pocus smart lawyer put them under a hypnosis and got them to do something embarrassing, because it was the only right thing to do and they had the courage to do it. And I will guarantee you, any of their neighbors or friends that were conservative, when they told them the number, if they gave them any guff, they'd have been sat down and talked to. And that person would have been another emissary to what we do and the proudness of what we do. Because every one of those people go, okay, I hadn't thought about that. And I bet you they used some of this closing argument when those moments came. So you can use that in a car crash. You take a knee injury, you got a torn meniscus, a torn rotator, and a herniated disc in their neck. And you just take each one of them. So that's another approach. And the last one is my experiment model, which is so important to this process of that I said personally in the believe phase is look at what it would be worth to you if you still had a choice. This is a still had a choice in the matter. And the way I do it is I usually pace, I'm a pacer. And when I start laying it out, I pace towards my client, looking directly in their eyes. And then I walk back as I'm moving to the next phase, and I'm talking about moving to the next phase, and then turn around and start laying this next phase eye to eye with the client. And it goes something, but you don't have to. Again, that's my style. Stand at the podium, don't move, do what it is the substance of it, not the style of it, that carries weight. And so the experiment model works something like this. If someone were to come to my client and say, we want you to partake in an experiment. We want to do an experiment to cause this kind of an injury or injuries to someone, and we want to follow them for the rest of their life so we can study how it impacts the quality of their life, their enjoyment of life, and all aspects of life. But Miss Jones, before you agree voluntarily to participate in this experiment, we need to have full disclosure as to what's coming before we discuss what's a fair and reasonable amount for you to go through this. So it's going to start, and you start at the beginning of the story. They're going to come to you, and you're going to get hit hard from behind. You're going to think you're going to be okay. You're going to be stiff, but you're going to go, and adrenaline's still flowing, the heat of the moment, you think you're okay. But you're going to go home, and the next morning, Miss Jones, you're going to wake up and go, wow, I'm really hurt and I'm stiff. Maybe I better get checked out. So you end up going to the emergency room the next day. And you get what sounds like good news when you go. That's what's going to happen. You're going to hear it's just a sprained strain. Nothing broken. We did x-rays, plain film x-rays, no broken bones. And you're going to be relieved, and you're going to go home. Like a week later, though, you're going to start feeling frustrated because it's not getting better. If anything, it's getting worse. So you're going to go to a chiropractor, and they're going to work on you. You're going to feel some relief, but it's going to be very temporary. And you get frustrated. And the chiropractor say, it's probably a sprained strain. Let's work on it. It's going to take probably a couple months. Well, 6 weeks later, it's not going to be in any meaningful way better, and you're going to be getting frustrated. And then I'll walk away and I'll say, but that's not the end of it. There's more to come. That's why I'm walking away, and I turn around and come back. And as I'm walking, I'm looking at him. I say, so what you're going to hear is you need to go see a neurosurgeon. You need to be checked out to make sure this isn't more serious. And you're going to go and you're going to hold your breath and they're going to order for you an MRI. And the MRI is going to come back with some bad news. And you're going to hear, look, this is not a sprain strain. You have torn up a disc. You've broken a disc. It's sticking out where it shouldn't and is pushing on nerves. It's called a herniation. But all hope's not lost. You're going to get some more good news. It may get better if we turn up the heat with the treatment. That takes away and I come back. So what comes next? They're going to send you to formal physical therapy. That's going to be frustrating and not help. Then they're going to send you to get injections and they're going to hurt and you're going to get some relief and you're going to have some real hope. My gosh, this could be the answer. Then I'm going to walk away and I come back. I say, but that's not the end of it, because after about 2 weeks, the pain comes back and they try another, this time an ablation. They go in and burn the nerve to kill that nerve. And you're going to be excited, even though it was a miserable procedure you went through, because you're going to be done with it and go, wow, this is the best I've felt since the crash, except the nerve's going to grow back. And now it's going to start hurting again. And you're going to be right back where you were. And then you're still not done, because now you're going to be 2 years out and the doctor's going to be talking about doing a surgery on you and do a fusion, which will make you stiff. And they're going to tell you it's a very dangerous surgery and there's no guarantee it's going to work. It actually could make it worse. You could be paralyzed, you could die, but it may make you better. And so you're going to put it off because you're scared of it. And there's no real reassurance it's going to work. But now 3 years out, you're going to say, I got to try. I got to try. So you have the surgery. And the good news is the burning down your arm goes away. The bad news is everything's stiff and you still have pain. It's still hard to sleep. The pain is with you. It's like a traveler. It's like having an unwanted visitor come to your house who's obnoxious, who never leaves. And you need to know this. And then that's still not the end of it, because now you've got the next 10 years. You're going to start getting older, and the normal aging process is going to lay over all of that hardware. And guess what? You're going to end up needing what's a surgery at the adjacent segment. It's called adjacent segment syndrome. And you got to go back through the surgery again. But that's not the end of it. And you walk them through all the way up to their life expectancy. It is a powerful storytelling. And then when you get to the end of it, you say to the jury or to your client, no, I've talked to the client, then I turn to the jury for this. Now, in fairness, wait a minute, I say this, would anybody start that conversation at less than $3 million? They would not. But in fairness, no one in their right mind would agree to do it voluntarily at any price. You could make it 30 million, they wouldn't do it. But no one asked my client's permission. This was thrust into her life unnaturally by no fault of her own. So it is a fair measuring stick. So that's the experiment model. And that is my 4 main damage models that goes with the audacity to ask for full value. You believe it and you validate it.
Excellent, excellent. Thank you so much, Keith. And before we end today, we do have a few more questions for you. So
one thing before we hit the question, because I'm going to forget this and we're going to hang up. Okay. 2 resources I just like to share. I get nothing from them. They're free. It's just John and I share that spirit of a rising tide lifts all boats. And we believe in the more we share with other people, the more we help globally our cause that we're all fighting for. 2 sources. I do these little audio podcasts. You can go to my website. They're free. They're there. I'm told there's also on YouTube and some other places. The place I know to go, it's keithmitnick.com. And it's not like Nick, N-I-C-K. It's K-M-I-T-N-I-K. It's keithmitnick.com. That's the website. And if you look in there for the podcast, they're called brushstrokes. I try to keep them at 10, 15 minutes, something you can listen to a car, listen to, do in between, doesn't take a bunch of time. And there's individual little strategies that are created into a little process or a little system, but brief on these very type things. I've got 4 years worth of them on there. I do them, they're one a month, and you can access any of them. It's free. The other is separate from that website. I have a listserv. It's at my, and you email me at my email address, which is kmitnick@forthepeople.com, FOR thepeople.com, kmitnick@forthepeople.com. Please, if you want on this listserv, include my assistant, Mary Arnold. It'll just save a step of having to forward it to her. It's marnold@forthepeople.com. And what it is during COVID, when I was stuck and couldn't go to New York to the studio to do those brush strokes that are audio podcasts, and I was frustrated because for a while I wasn't in trial. I've had now 11 jury trials in COVID, but early there were none. And I was walking on the beach and I was talking to our lawyers on the phone all day, problem solving. And I had all these new, fresh ideas I was sharing with the lawyers, and I wanted to get them out. And it was maddening. I couldn't do my brush strokes and get them out audio. And I realized, Mitnick, it ain't that hard, type them up. So I created what's called at home but not alone brush strokes. And I made a commitment to keep them short too. I think the longest is 3 pages. A bunch of them are one. They average about 1.5 pages. I was doing them every week. As trials are picking up, I'm doing more like one a month, and occasionally it's gone a little longer, but I am going to do those for the rest of my life. They are meaningful to me. I share them in-house to our firm, and then I share them on my listserv. If you want them, if you email me and say, hey, I enjoyed it today and I'd like to be on your listserv, Mary will add you and catch you. I've done like 41 or 2 of them. She'll catch you up on all the old ones and start getting the new ones going forward. Okay, having said that, now questions, please.
Fantastic. So our first question is, how do you rebut the defense assertion that a chiropractor is not a real medical doctor during closing?
Yeah, I start that in voir dire. I just did it in a case. And I said, listen, we're going to have chiropractors testifying and medical doctors, pain management, neurosurgeons, radiologists. We have all kinds of doctors. But I need to ask you specifically about the chiropractor. Some people go to chiropractors, believe they provide a great service, and they are very knowledgeable, and it's an important part of managing particularly spine pain. But other people say, I wouldn't let one of them touch me with a 10-foot pole. I think they're quacks. And here's why I'm asking, because I don't want to get into your, it doesn't, who you go to treat your problems isn't why we're here. I'm going to ask you how many have been to chiropractor or how many haven't. And I do. I want to know that as kind of a background. But I say what I'm really concerned about is how many of you would say, you can certainly weigh credentials, MD, chiropractor, those are fair considerations, along with a whole bunch of other things. But sometimes being a chiropractor kind of becomes a be all end all to someone if they think they're a quack. So I need to know how many of you say, honestly, I could not rely on what a chiropractor says to make a decision in a lawsuit like this, period. I've already made up my mind. I'm going to reject his advice in this case as to what the injuries are, is his opinions. In all honesty, this is an honor system. I need to tell you. How many of you feel that way? And you'll find out, I actually, every time I do it, there are a lot of people go to chiropractors, but in every panel, you're going to get some say that, and that's a cause challenge. So I remove them, and then I don't talk to them because I've covered it. I go to the others and say, so you're going to be able to give them a fair shake in their opinions and don't have any bias against them. No, I don't. And then I don't talk about it anymore. I deal with it not in closing, not in opening. I deal with it in voir dire. And from that point forward, they're just another doctor as far as I'm concerned.
Okay, that makes perfect sense. Another question is, have you had any judges who have not let you get a pre-commitment from the panel as to a limit on damages? And if so, what do you do in that scenario?
Yes, I have. Not often. I've had objections. I had a judge that up in Mississippi who said, the other side said, he's just talking about it was it was not a mild traumatic brain injury. It was a severe traumatic brain injury case. And I said, we're going to be talking about millions and millions and millions of dollars. And the other side went up whining, late in it. I'd already gotten a bunch of cause answers. And the other side went up to the bench and said, Judge, that's ambiguous. And, he just means, man, we don't even know what it means and blah, 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 blah. And the judge says, I agree. I said, okay, well then I'm going to be asking for, $50 million. I'm going to just tell him. And the judge said, the other guy said, no, that's improper. He goes, well, you've just objected that it's ambiguous. He ought to be able to do it. And so I then turned around and said, look, folks, I've been talking about millions and millions and millions of dollars, but because I don't want there to be any question that it's ambiguous what I mean, I'll go ahead and tell you, I normally wait until I presented the evidence to you and laid out for you my damage models of how I got there so you can assess it at the end. But I need to let you know, in fairness, we're going to be talking about a lot of money, so I don't surprise you. That's not fair to you or my client. But because there's a question about what's that phrase mean, let me be specific. When we get to closing and have an opportunity, you've seen the evidence and I can talk about damage models, we're going to be talking about $50 million. Now, how many of you say, no way, no how, I don't care what the evidence is, I'm not signing off of a verdict of that. Not only do you have a little bias, I got a big bias against it. That is against my core beliefs. Guess what? Every damned one of them that had said yes to the other one gave it stronger that go around. And so, but have I had judges that said, you're pre-trying your case? Yeah. And I said, Judge, I'm doing the opposite. I'm making sure this case has not been pre-tried. I'm not asking for commitment of what they're going to do. I want to make sure they've not already reached a place they absolutely aren't going to go there. Now, why do you don't want to be associated with? Because my first way I did it was to say, wouldn't be comfortable no matter what the evidence, bringing back a verdict of X amount. You know what I hear at the bench? Well, what if he said $70 trillion, Judge? Would that be a cause challenge? He can't just make a big number up and run people off because they say they couldn't do it. And I said, Judge, I didn't say 70 trillion. I said what we're really going to ask for you. Well, yeah, but he's got a point. And I had a judge stop me on that. So I went back to the drawing board, and it's gone much smoother with we're going to be talking about millions and millions or millions of dollars. Who doesn't want to be associated, report to friends, neighbors, da, 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 and you feel strongly enough about it, it's a belief of yours that, in all honesty, you cannot assure the court that bias, that belief will not impact you in addition to the evidence. Now you can't say, well, he could pick any number. I didn't pick any number. I was more vague, but the concept of a significant multi-million-dollar verdict or $1 million verdict has fairly been put out. You can't spring that on a damn jury later. That's crazy. It's not fair to the jury. You got to give them an opportunity to say, this one isn't for me. It's an honor system. I mean, we owe it to them, plus our client. It'd be malpractice not to go into it. So, and you can't say a large verdict. Someone could say, I'm all right with a large verdict so long as it's not more than 30,000. I mean, so you got to give them some parameters. But yes, it's a dicey area. Go in ready with your arguments in your head and your law ready, because you may run into resistance. But I get much, asking it that way, the resistance I face is so much less. And when I do face it, I almost always, the judge goes, okay, but move on. You don't need to keep saying it. And I don't keep saying millions and millions. Once I've said it once, I start saying a large amount, a significant amount, a verdict of that magnitude. Because I know if you say it over and over, A, I worry the jury's going to think this is a mind brainwashing exercise. And number two, it's more likely that you're going to have to go spend a little time out up with the judge. And I don't want to go sidebar. I want to talk to these people. So, but yes, beware, but this has caused less problems for me than any other way I've asked about it. If someone throws in one more on it, every now and I used to ask about people believe there ought to be a cap. I ran into the same thing with the judges. What's the cap going to be, Mr. Mitnick? So I've quit the cap question. But if I get it, a juror throws in, well, there ought to be a cap. I have never asked a juror what the cap ought to be and have them say X. They never have a number. That's part of why the cap doesn't work for me. But I found a way to convert the cap when they don't give a number into a cause challenge. When they say, I don't know, I say, okay, I don't want to put words in your mouth. Tell me if I'm off the mark. But it sounds like what you're saying is you are likely to establish a cap during this trial, but you don't know what it is yet because you don't know enough. Yes. And once you establish that unknown cap as we sit here, you're probably not going above it, even if the evidence supported it. That's correct. Then I move for cause because I say, Judge, and that's the truth. That's your best honest answer. And while you may try to put it aside if that's not the law, and you're not going to thumb your nose at the judge on the law, you're telling us your best honest answer. You're probably going to be applying some cap of some undetermined amount when you get into deliberation. Yes, that's what I mean. And if you try not to do it, you couldn't assure the court you could successfully say, for sure I won't. That's right. That's a cause challenge. They say, how's that a cause? I say, Judge, there's going to be a cap. We don't know if it's $10 or 10 million, but there's going to be a cap. And whatever that unknown amount is, he ain't going over it, even if the evidence supports it. And I doubt you're going to let me, right before deliberation, re-ask this question and then take them out for cause. Now's the time. Okay.
Understood. And lastly, there have been several compliments throughout the entirety of your presentation on how helpful this information has been. But this specific person said, is there a resource in writing that discusses stuff like this? I need it. So I wanted to give you another opportunity to potentially elaborate on your books or any other books you might recommend.
If there's so many good books out there on this stuff, go to trial guides and look up and down the trial guides list, read reviews. They have fantastic books. And I've read damn near all of them. I can't remember whose is what and where, so I won't cite to them. The one I do know what's in it is mine. It is Don't Eat the Bruises is the first one, which really lays out how to establish, how to become a master of establishing cause challenges, because you almost never have enough peremptory challenges to have a fair fight. So it's all about getting a fair jury by becoming very good at cause challenges. And then it takes you after voir dire through the entire trial, opening statement, cross-examinations, direct examinations, closing arguments, the power of analogy. There's just a whole bunch of kind of A to Z, everything I've learned over the years of trying a bunch of cases. And I threw out the stuff that didn't work and put in and didn't keep the stuff that kind of worked. It's all the stuff that really, really worked, all in one place. The second book of Deeper Cuts was simply, I realized I had a bunch of new stuff, and I did something on med mal I'd never done before in writing, and I did a whole section on med mal in there. I explained the thought process that I used that comes up with these systems that are in the first book. I showed all the new stuff, both in voir dire and in trial. There's a really section that I love that I call Beauties in the Eyes of the Beholder, where all these problems like gap in treatment, not a lot of visible property damage, not going to the doctor right away, priors, aggravations, everything you can think of that comes up in these cases that the defense tries to turn into a big mountain of a problem that we think's a problem. I've gone through and explained they aren't problems. You still got to deal with them, but they're not problems. And why does it matter if you still got to deal with them, whether you call them a wannabe problem or a problem with an answer? The answer is, if you look at your caseload and you go, gosh, every one of my cases is just littered with problems. You get up in the morning and say, why me? Woe is me. I got to go work on my cases. This is too hard to get up in a bad mood. If you realize none of those are problems to start with and you got an answer for them, then you love your cases. You get up in the morning and think, thank you, God, for my caseload. It changes the spirit of it, which matters. So there's a whole section. There's a section on what I call false framing, how they put things in a false frame to make it sound like this is the dispute, because they know they're going to win that dispute when it's not even the dispute. It's a trick. And I got a whole section on, the first one has a whole section on creating the language of your case, these powerful words and phrases and adages. This book, I came up with an actual formula that helps you pick the right words. That works. I use it all the time now. You just plug in the word, you run it through this almost equation, and you'll figure out nope, yep, and why. So there's just, if you put those two together, it's every good idea I've had in my entire career that I still believe in and still use today. From me personally, that's my resource. And then there are these little gems of the at home but not alone brushstrokes from the listserv or the audio brushstroke podcast that are on the website. And that's the best I have to offer, but there's a lot of other people. And if John Romano will talk to you or share with you his writings, for goodness sake, don't skip them. He's been doing it even longer than I have.
I've been doing it a while. Keith, this has just been extraordinary. And the comments that we're getting and the emails coming through, people not only just love you and respect you and adore you, but they are in awe of your ability to teach us all how to do these things. And your sharing of this, the secret sauce, so to speak, has been amazing. And I just can't thank you enough for doing this. This has been quite an effort. And the time you've spent this afternoon with everybody, just extraordinary. So thank you. I can't wait to have you back and we do more of these. And I know I'll be seeing you at some of the locations where we do these around the country.
Call and ask me to come. When I get a John Romano email, can you come? Unless I literally just can't because of a big trial, I will always be there because I feel a debt of gratitude to you. So
thank you. Thank you. All right, Ginger and Michaela, thank you so much for what you've done to help us today. It's been great. And I'm going to turn it back to Ginger, all yours.
Yes, I want to thank you guys so much for today. Like, this has been amazing. And honestly, I really wish it wasn't over yet. I'm not ready for it to be over. This has been so good and so valuable. And I cannot thank you enough for your time today, Keith. I'm speaking on behalf of everybody. I've gotten numerous messages on the break where everyone's like, can we get a copy of this? You know, I really want so-and-so to watch it. And I will be in touch with everybody after the webinar. And if everything's okay to share, we will share this with you today. But Keith,
yeah, it is okay to share. You got my blessing.
Fabulous.
To share.
All right, well then give me just a little bit of time and I will have this link posted on our YouTube channel and I will share a copy with everybody. So stay tuned to your email. Give me just a little time to download it. But this has been phenomenal. And thank you so much, Michaela. It was wonderful to have you with us today. Please come back because I loved the questions. They were very good.
Yeah, Michaela, it was your smiling face and your sparkling eyes made it all worthwhile. Thank you.
Thank you. It was an honor.
Absolutely. And before we go, you guys, we still have one great big announcement. Ted Mullis from HMR, you know, our favorite guy who comes in on every webinar and gives away coffee to one lucky winner. And by the way, this is always live. We literally look to see who's watching, who's on. Ted sends a list of names and I see who's the first one on and they're the winner. So don't forget.
I'm going to step off, Ginger, because I got somewhere I'm supposed to be. Thank you for having me.
Absolutely. We'll have you back here soon.
Thank you again, Keith. Okay. Bye-bye.
Bye, Keith. And Ted, I cannot thank you enough for being here again with us today. If you can, tell us who the grand winner is.
Sure. So I'm pleased to announce that it's Mark Delphin out of Lake Charles, Louisiana. He's the last winner for 2021, and we'll start all over again next year.
Congratulations.
Awesome.
All right, Mark. Well, Ted and I will be reaching out to you in a few moments. And Ted, thank you so much for doing this day in, day out. We'll
always my pleasure.
Mark this is brand new coffee too, which is coming out next year.
Yep.
So thank you again for all that you do. Big thanks to HMR. We will see you very soon, a few more months. We'll all be in Nashville together and I'm looking forward to that. So thank you again.
You're welcome. Happy holidays, everybody.
Happy holidays and Merry Christmas.
Okay.
And I wanted to show you guys also this contact information for Keith, for John, Michaela, and all of our incredible partners. Big thanks to HMR, OnPoint, and Plaintiff Support. I am going to send this to you in the email as well in just a few moments. but please stay in contact with everybody. If you have any extra questions, don't be afraid to reach out. And I want to thank everybody so much for all of your huge support this year, for these incredible webinars. We cannot do it without you and our incredible partners. And John Romano, thank you for making it possible, because
Hey.
I
Well,
literally, I'm at a loss for words. I get so many positive comments from everybody saying, please keep doing these webinars. We've been doing them since April 2020. And John gave us the word. He said, we're going to keep going. So I hope
we
that you
are going to
continue.
keep going. We are not going to stop with the webinars, even though I'm so excited that the live seminars are coming back. And I can't wait for our big seminar, TBI Nashville in May. But Ginger, a special thanks to you. This has been a fabulous year because of Ginger primarily. And I know it, everybody knows it. So a very, very Merry Christmas and happy holidays to you, Ginger, and to everybody who is attending, and to our sponsors and Michaela and everybody. So have a happy, healthy, and safe holiday season.
Absolutely. We love you guys. Take care.
Okay.
Until next
Merry
time.
Christmas.
Bye,
everybody.
Take
everyone.
care. Bye, everybody.